companies do give the rules, what is allowed, what is not allowed, but they don't really give examples of what these rules mean. But one specific indicator that I want to highlight on which all companies in our index scored 0 is that data about terms of service enforcement. So if you recognize that terms of service are so critical to how behavior and content that users are communicating online, or when they use a mobile phone and whatnot, then at least we should know how has the company dealt with this. And across the board, from the companies that we looked at, we don't have any such information. It is one big black box. So when companies, for example, do report, they say, well, we've taken down content on the request of this and this government. They give 0 information about content that they've restricted based on their own terms of service. So they say we have these rules, and evidently, because we know of all sorts of content being restricted on social networks and other platforms, we know the content is being restricted, but we get no evidence of numbers from the company itself to help us understand what is actually taking place, what are the circumstances under which content has been taken down. And as a consequence, for us as users who want to hold these companies accountable for these platforms as platforms of free expression, we have much fewer means to do so. So that is something that we hope that companies will improve much upon as well. Thank you.
Just I want to, if I may ask you to further expand a little bit on what are companies, can you provide some example of what are companies doing in reality as regards terms of service? What is their attitude? What are the practices that they are developing?
Yeah, so these are basically the things that I just mentioned. So their behavior toward these terms of service aspects is quite dispersed. So they do make terms of service available, but they don't necessarily give concrete examples. If we want users to understand how their behavior is being guided by these terms of service, then companies should treat users as their primary audience. They shouldn't talk to, they shouldn't regard lawyers as a primary audience. They shouldn't regard governments or regulators as a primary audience. The key thing is that users are meant to understand how the company is ruling their behavior and content they communicate. And that, across the board, is not looking so well for companies. Oftentimes, as we also discussed in the previous meeting in the Dynamic Coalition, terms of service are not read because it is way too challenging for anyone without very specific legal knowledge to even understand what they mean. They are very long, etc. Some companies go a bit further by, for example, creating things like community guidelines where they try to give more specific examples. Okay, these are the rules in more plain language, what you're allowed, what you're not allowed to do. And these are the kind of steps that we hope companies will take much more to treat users as their primary audience, to help them understand what they can and what they cannot do.
Thank you very much. I believe this is the right way to go. So saying that terms of service should be really for users and not as a legalistic way for the company to protect, behind complex terms. And also, I think from a technical perspective, sometimes they can be very complicated to understand, and the examples that you mentioned are very useful. So with that, I just have in mind what was done at the Getulio Vargas Foundation in the project of non-terms of service, in which I was partially involved. And I'm wondering if Jamila can explain to us more or less what were these complexities in assessing terms of service, and how there was a need for an interdisciplinary team, so to say, talking about lawyers, technical persons, knowing how the service needs to work from a technical perspective.
Yes, thank you, Nico. Just to highlight, building on what Alon was saying, it's important, it was very strong, the feeling that we had, the difficulty that we have while analyzing the terms of service of 50 platforms for this project. Besides not having any information on how the terms of service are enforced, there is little information on how a user can report inappropriate content, for instance. So there, usually you can find rules on what type of content is allowed or not in some platforms, but it's very difficult to understand what can you do if you find some inappropriate content or something violates your privacy or something like that. So it's very complicated for the user to understand what are their rights and obligations while interacting with a platform. Besides that, as Nico was saying, it's important to, we found that a great challenge was to determine what was justifiable, what was reasonable while collecting data, for instance, especially in regard to privacy practices. So what is reasonable, what is necessary for the operation of a platform, for instance? That's an expression we usually find when they are talking about tracking, for instance, tracking users in other websites, which is a very common practice among the platforms that we analyzed. So what does that actually mean? How do you classify how do you understand what's necessary or not for the operation of a platform in terms of the data they collect? Another justification that we would find very commonly on the terms of services that they collect data or that they perform certain activities in order to provide better services for users or to create new services. To what extent that justify the collection of data from users? To what extent that would be something that the user should or not consent to while using some type of platform, especially considering that there are accepting the terms of service is usually the price that you pay to have access to some services nowadays. So these were some of the issues that we faced during the project. So as Nicolo was also saying, it was and it is necessary in order to improve the methodology that we use to assess how terms of service are complying with international human rights standards, to have a multidisciplinary approach, and more than that, to have cooperation among different stakeholders to understand how these things really work. It would be very valuable in order to improve this methodology, to hear from companies how they classify or how they analyze these things, that for a regular user wouldn't mean much. That's necessary for the operation of the platform. We use this to develop statistics and research and to improve our services. It would be really interesting and really important to understand what this really means in order to make a clear assessment of how these terms of service work.
And if I understand correctly, this is precisely what this terms of service project, terms of service and human rights project, is aimed to do. So to clarify in lay terms what can be very complex at first sight. And I think it is important to indeed engage with the companies to understand what they mean when something is generic, let's say, in the terms of service. So this is just to explain, because we didn't introduce the project as such. And I'm wondering if you can also tell a little bit about how this project can be useful, in particular in Brazil now, as there is this reform of data protection law and the implementation of the Marco Civil. If you think that these preliminary results that you have can be informative towards the way forward.
Yes, so the Terms of Service and Human Rights Project had this double role. In one hand, one of the goals is to provide better information for users by assessing these terms of use and trying to identify what are the practices, the common practices, and how platforms are complying or not with human rights by analyzing exclusively their terms of service, privacy policies, and binding documents. On the other hand, it was also a very interesting way of understanding and mapping common practices developed by these platforms. And in this sense, especially this first phase of the project that was basically trying to develop and implement and enhance the methodology to analyze the terms of service, we could have an interesting map of common practices by these companies that was already useful in the public debates around the decree that will regulate implement Marco Civil da internet, and on the other hand, on the debates around data protection, draft bill for data protection in Brazil. It is important to point out, just as for context, for the ones that don't know, Brazil has sparse norms regulating the right to privacy and data protection, but it still lacks a comprehensive law to deal with the processing of personal data nowadays. We had 2 public debates. We have 3 bills pending or being discussed in different chambers of the Congress right now. And something that, and these results were already useful for Fundação Getúlio Vargas to give input to the Ministry of Justice in these public debates. But something that I would like to leave open, for discussion, for further discussion, is that Brazilian consumer protection law is already very strong in determining that abusive clauses of any contract will be declared null or void. Although without the data protection authority, it's very difficult to implement this in the online environment, and considering the great amount of services that we use and the fact that we are regulated by terms of service even when visiting a website and not just platforms, how to enforce this type of clauses, I think is still a challenge that we will have to face internationally, and I hope and we hope that this type of project can give input to this type of discussion also.
Thank you. So staying within the Brazilian jurisdiction, actually, I think you mentioned consumer protection law, but there is also another way in which terms of service, in particular model terms of service that we can identify based on the data that we have with this project. So model contractual clauses that serve to protect consumers can be incorporated into the law. So this is a particular procedure that takes place in Brazil, whereby prosecutors can basically come to an agreement with companies with regard to the way forward in which they are going to interact with users. And this is called termos de ajustamento, that's correct? So I would like Neide to tell us a little bit more about how this works.
Good afternoon. As Lucas said, my name is Neide Oliveira. I'm Federal Circuit Prosecutor in Rio de Janeiro. And I'd like to start off apologizing for my English. I've been practicing, but I'm not as fluent as I would like to be. Anyway, I will do my best. The Federal Prosecution Service is a prosecution authority which has a peculiarity in Brazil, as it is the authority responsible for filing class civil actions aiming the protection of civil and social rights, including environment. The human rights protected by the Federal Prosecution Service on internet are concerning child and hate speech crimes, because Brazil has signed the United Nations Convention on the Rights of the Child, as well as the International Convention on the Elimination of all forms of racial discrimination. The Federal Prosecution Service created specialized groups to investigate and prosecute cybercrime in 2003 in São Paulo and 2006 in Rio de Janeiro due to increased hate speech crimes and child pornography. Those groups have the following attributions: investigation and prosecution of criminal cases, operations in judicial and extrajudicial cases, signing of compliance terms, agreements, recommendations, and conduct adjustments term, enforcement activities, preventive activities to carry out of workshops in school about the safe and ethical use of internet. I will do a lecture about these workshops tomorrow. So the terms of commitment or cooperation are agreements to address the law shortcomings, seeking the internet company's assistance and voluntary collaboration without any prescribed sanctions. The conduct adjustment term serves to end or prevent a public civil suit filing where there is a violation by the online provider regarding any law or right, which can be settled with the TAC compliance. There are sanctions in case of breach of its terms. The TAC, the TCA, is equivalent to an extrajudicial enforcement order. On the other hand, we can say the whole of online providers' access and content in combating cybercrime concerns the preservation of crimes evidences, as well the user identification. They must create filters in order to prevent uploading of illicit material and also disclosure the hotline link to all its potentially dangerous services, as chats, blogs, online communities. Concerning to the operation integration compliance term between the Federal Prosecution Service and content providers, its purpose was the prevention and prosecution of child pornography and racism. In fact, its main goals were the prevention, campaigns, development, banners publication, users guidance, notification to the Federal Prosecutor's Office about any occurrence as foreseen, data preservation and storage for telematic data secrecy removal. We can also condense a brief history about the terms of commitment and the conduct adjustment terms in Brazil. In 2005, it was signing the first operational integration compliance term between the Federal Prosecution Service in São Paulo and Brazilian content providers or forgers located in São Paulo. In 2008, it was signed a conduct adjustment term between Google and the Federal Prosecution Service in São Paulo. We had a class civil action against Google, so we finished this action with this conduct adjustment term. In 2009, it was completed a mutual cooperation term between the Federal Prosecution Service in São Paulo and the Internet access providers. Also in 2009, the Federal Prosecution Service in Rio de Janeiro and Brazilian content providers located in Rio de Janeiro signed cooperation terms. It's the same of that São Paulo did in 2005. In 2014, we tried to sign a conduct adjustment term between Secrets, an American mobile app, and the Federal Prosecution Service in Rio de Janeiro. But I will explain about it in my answer.
Yes, thank you very much. So actually, I was going to go there because this is the famous case that took place in Brazil last year, whereby Secret was required to change the term of service because of the provision in the Constitution of Brazil which forbids anonymity, as I understand. So there was an issue of actually changing the terms of service only for Brazil, and the company was American. Mm-hmm. So how did this situation develop? How did it ended up? If you can tell briefly what the story was.
Okay, the North American app Secret, which was used in closed groups and was supposedly anonymous, marketed by Apple in iPhones and Google Android smartphones, quickly spread in Brazil in 2014, especially in the school environment. The company did not have representation in Brazil, and the app diffusion was so intense, with the possibility of allowing people within the group not to be identified, that soon emerged crimes as cyberbullying among adolescents, as well the exchange of child pornography material. The investigation authorities, law enforcement, had no way to identify criminals due to the lack of contact with the company. It turned out that a public prosecutor in Espírito Santo, a state of Brazil, attained a court decision with national reach, which prohibits the marketing of the app by Apple and Google. Although Apple complied with the decision, Google did not, and so the application continued to be used by students until that. In Rio de Janeiro, a policy commissioner delegate consulted the Federal Prosecution Service, demanding for support with the issue, consider our international operations. Therefore, the Federal Prosecutor in Rio de Janeiro, Ana Padilha, managed to obtain the company address in the United States and notify them, in Portuguese, to present themselves before her. The company indicated lawyers for the task, which were very pleasant with the contact. So they began to outline the terms of the conduct adjustment, in which was predicted the immediate creation of an email address to exchange information with the law enforcement authorities, a link in the app to explain that the service would preserve the user identifier as long as he was not committing a crime, in which case the user identification would be disclosed to the authorities and others. However, over the time of Apple's no marketing of the app, awaiting the completion of the terms of conduct adjustment to reoffer it at its Apple Store, Secret fell into disuse, so the company chose to leave the country, not signing the TCA. Not long ago, I learned that the company was closed in the United States. As a lesson to the Federal Prosecution Service, we shall conclude that the companies, before launching their service in a country, must know its law and how its institutions work. Certainly, the secret company was completely unaware of the Federal Prosecution Service procedure at the protection of the public social interest in Brazil. This social interest, which reach an undetermined number of people and whose eventual damage can't easily be measured, and the reach of the judicial decisions in the country. In the case of the secret app, which was so successful in Brazil, a country with continental dimensions, it was surely a pity, including from the consumer's point of view, which could not use such a popular app like Secret anymore.
Thanks a lot, Neide, for this concrete example. And I think now we could just switch of geographical perspective, going to Europe and European Union more precisely. And we should consider that both terms of service adopted by online platform and both and terms of service adopted by internet service provider can be actually shaped by regulation. Actually, they have to comply with regulation. So we know that the European Parliament is considering some platform regulation. So I would like to ask Matthias to provide us a couple of information, maybe some provocation, on what could be the effect of such platform regulation on terms of service.
Hi, yeah. I will have to disappoint you all and say that at this point that would be speculation. Fortunately, I don't mind speculating. So the European Commission launched a digital single market strategy in May this year, which outlines their ambitions for the next coming years. And one of their key priorities is platforms. And they have a They have a growing concern about the market dominance of some platforms and how to manage that. And therefore they launched, as a process in legislation, and this is where we currently are, they launched an online consultation on platforms, well, and on regulatory environment for platforms, online intermediaries, data and cloud computing, and the collaboratory economy, which would be the consultation, short name. It's an open consultation. You can all find it online on the Commission webpage. and you can also submit comments. And the insightful comments from my colleagues here should probably be inserted into that consultation. Especially any data you have would be very useful. One thing in particular to take into account when you look at the consultation is that we've mainly been talking about platform to end user interaction and terms of services. But the EU Commission is equally interested in, or maybe more interested in, business to business terms of services. As these platforms become ecosystems where a lot of other companies have their products on, and a quick change in terms of services can basically be devastating for a growing business if the model where they are working with is no longer functioning. So the consultation is ongoing. It ends in December. And if you ask the Commission, they will say that until the consultation is over, they don't know where they're going. And after the consultation, they will start formal discussions with European stakeholders, and then at some point next year they will launch hopefully a legal proposal, and that will take 2 years of the European legislative process, and then we might have either a regulation or directive which then has to be transposed into national law unless it's a regulation. So it's not anything that happens tomorrow, but it will happen. There's a huge push in the Commission for doing something with platforms, and there's a lot of talk. Whenever you listen to the commissioners, they will mention platforms one way or another. And they have a whole section on transparency in the consultation, so clearly that is something where they will probably want to regulate. One of the first questions is, do you find the information provided by online platforms on their terms of use sufficient and easy to understand? That's a yes and no question. My guess is there will be more no's than yes on that question in particular. And then the next question is, if no, what's the problem? And then you can write rather extensively what the problem is. And that is clearly showing that they want to have some regulation on clarity. Exactly how that will be shaped is, of course, yet to be determined. But I think that is one of the key issues the conclusions we can draw at this point, is there will be some kind of regulation on transparency and clarity in terms of use or terms of services. Other than that, it's very difficult to tell at this point. So I would really encourage everyone who care about the topic, which I think you all do, to actually go to the Commission website, look at the consultation. It's super easy to put your input there. If you don't think the questions are good, which you will not do, then you can easily submit a position paper as well. You don't have to be confined to the questions. If I should criticize the questions, the first question is, this is our definition of platform, is it good or bad? Or do you agree with it? And the problem is, of course, that the definition of platform would equally apply to a huge platform like Google or Facebook, to a little privately run blog which have ads and a comment thread. They would all qualify as platforms. And clearly, and I hope and I think the Commission don't think a one-size-fits-all solution for this span of entities, but the problem, of course, when you have one definition for everything is that it gets very tricky to regulate. But at this point, it's very difficult to say what will come out of it, but we will have some regulation. And of course, any terms of services that doesn't comply with national legislation will be void in those countries. So this will restrict, it will not restrict what they can write in their terms of services, but it will restrict what will actually be applicable in those terms and services.
Yeah, thank you very much. And having in mind that platforms are not the only intermediaries using terms of service, of course, and that recently, just a couple of weeks ago, the European Parliament has approved the new telecom single market regulation that also includes some net neutrality provisions. And the adoption of these provisions were at the very beginning stimulated by a joint investigation of BEREC and the European Commission that found that almost 50% of the mobile users and 20% of the European fixed internet users were were affected by restrictions in their internet access, and those restrictions were clearly mentioned in the terms of use of the internet access service. So do you think that 20 to 50% of the European internet users will now have modifications of their terms of use due to the new regulation?
I would say no. I don't think they will update the terms of use unless compelled to do so. But the package you're talking about, the telecom single market or connected continent or second telecom package, we like to rename everything every now and then. Whenever we have a new person involved, they will put a new name on any legislative proposal so they can have their own press release about it. That one had initially a section on rights for users that would basically be very directly targeting what you could put in terms of service or what would be valid in terms of services. That was in there as part of it. When it comes to internet service providers, it would be the right to get the speed in the actual speed and not possible speed of your internet connectivity or connection. That entire part was taken out during the negotiations between the institutions in the EU. And generally they referred to the Universal Service Directive, which is another legislation that will be reviewed some point in the near future. And they said that users' rights should not be spread out in different legislations, it should all be pushed there. So, of course, with platform regulation, that will not be the case. They will still spread it out. But we will have also not only the platform regulation, but we will have the Universal Service Directive review, which will give regulation on terms of services for all services, platforms and intermediaries and offline services.
Thanks all for providing this perspective. Now I would like to open the floor for questions and comments. So if you have any comments or questions to the panelists, please, or any observation, feel free to speak. Do we have any? So let me introduce you, Natalia Fodic, who is our kind remote moderator.
We have a question coming from Tiago Sombra. His question is, what kind of instruments, tools, policies are companies developing to improve their data protection commitment?
Please be my guest. Matthias?
Well, since no one seemed to have a quick answer, I will allow myself to speculate again. None at the moment. Companies rarely do anything unless compelled. Currently, there is another legislative regulation in Europe on data protection, and that is almost finalized. And since Europe is a rather big market, I'm pretty sure that most companies are waiting to see what comes out of that package until they develop any tools. But this will be hopefully finalized before the end of the year. And then quickly thereafter, I think we will see companies hurrying to try to comply with it. So right now, very little. In the next year, I think they will start to try to develop tools to ensure that they comply with the European standards on data protection.
Okay. Alon, I think, want to react, maybe Jeremy? First.
Sure. I think that some of the things that you see some companies developing in terms of data protection is giving some customizability of privacy settings to their end users. So, for example, sometimes users now have an option where they can say they do not want to see targeted advertising or such things. The fact of the matter is that oftentimes when any such customization of your privacy settings is possible, it is really rather limited. Oftentimes there's no ability to, for example, opt out of data collection by the company. So they may say, well, you won't see targeted advertising anymore, but you can't necessarily say anything against the data collection practices in the first place, or any other kind of sharing of your data that goes beyond of sharing with advertisers, but perhaps reaching other parties. So I think some small steps are being made, but overall users should have much greater control, as is sometimes established in law, to have access to their own information as the company has it, and be able to edit that information, modify it, withdraw it, etc.
I agree that we haven't seen a lot from the companies yet, but I do also think that there is mounting pressure, particularly for the US-based platforms, to bring their data protection standards up to scratch, particularly with the rejection of the EU-US Safe Harbour Agreement. That's going to bring increasing pressure to bear, depending on how that ends up being resolved. And also the General Data Protection Regulation that was referred to, which will certainly have an impact, and we don't even know yet quite to what extent. But I think the writing is on the wall for the practices of the US-based platforms, and they're going to have to bring themselves up to a higher standard.
I'd like to share the global observation on this, because if you go beyond Europe and the US, and you will see the internet companies...
Sorry, can you speak closer to the microphone?
I think that if you go beyond the Europe and the US, you will see the intermediaries in the developing world are operating in a much worse legal environment, because no data protection law, no privacy law, no even free expression regime in place. So it's really a very big gap in this aspect. And also another gap I want to draw our attention that compared to those big global companies, like we discuss a lot in this Google, Facebook, there are many small, local, regional companies. I mean, they are really in a very much weak position to practice effective self-regulation, not to mention to comply with international standards and in any circumstance. So I think that maybe we need more research. I don't know if the foundation's research, I mean, I appreciate your human rights assessment on the 55 platforms, terms of services, right? 50, yeah. I don't know how many are from the developing world, and if that shows a gap, it's huge, and that will be one aspect we should look into further.
We didn't analyze platforms specifically from the developing world, but we see a big difference between small platforms and bigger ones, as you were saying, even newer or smaller ones. Just to give a general overview of some of the practices that we find regarding data protection, what we see on the terms of use is that most platforms ask for consent to collect more data than necessary for their operation, considering the methodology that we use to assess what's necessary for their operation. Most of them tracks users in other websites, allow third-party tracking, meaning that they put ads or other types of mechanisms that allow third parties to track users' activities on their website. All of that considering, of course, just the terms of use, meaning that they ask consent to do all of this. Most of them retain data for more time than necessary for their operation, or they are unclear about how long will they keep that data. And most of them share user data for different reasons, commercial reasons, processing, or other reasons. All of that by default. And I think that's something that could be further discussed on how that could be, how users could have more choice on that. I mean, nowadays they ask for consent to do everything by default, and if you want to opt out, some of them allow users to opt out. Some say nothing about that on their terms of service or give unclear instructions. That doesn't mean all that's to say, with regard to what the documents, the binding documents say, this is like the situation that we find, and is not very positive for data protection and the protection of privacy of users. But on the other hand, we didn't analyze the implementation of this, and we understand that there are several companies doing improvements in privacy options, privacy settings, and giving more options to the user. The only thing is that we find concerning is that they are not committed to do this, to give this type of options on their binding documents.
And also another element that I think is worth considering from the terms of service and human rights project that I was also pointing out in the workshop we had this morning at the Ranking Digital Rights is that almost around 20%, so 1/5 of the platforms we analyzed, contain in the contractual agreement a waiver of any class action. So meaning that by accepting the contract that no one reads, 1/5 of the platform imposed to the user to waive its right to have a class action if the contractual provisions are not right. So that is actually a very interesting element. I think maybe Alan has a comment on this.
Thank you. Yeah, so one of the things that we were also looking at is indeed what can users do to file grievance when they feel that the right to privacy or the right to free expression has been violated by a company's conduct. And if you step back a little bit and sort of think of, well, if companies are using these terms of service and their privacy policies to implement all sorts of measures that basically go beyond what they're required to do by law, by, for example, imposing further restrictions or collecting certain data, etc., then it seems sensible that these platforms should actually also provide some way, some access to remedy for their users. And this is actually one of the key pillars of the United Nations Protect, Respect and Remedy framework that tries to outline what companies should be doing to respect the human rights of their users. And so that access to remedy is really important, that users have some way to protest, to complain, to seek remedy, find redress for what the company is doing. And when we analyzed how companies, the 16 companies in our research, and by the way, I forgot to mention, you can find all the data, all the results are published on our website, rankingdigitalrights.org. When we looked at how companies performed on this specific indicator, we found that generally, I don't think any company got higher than 50% of the score. The two highest scoring companies in our ranking on this were Bharti Airtel in India and Kakao in South Korea, who by law have some obligation to provide some access to remedy. For example, in India, there's a law that prescribes companies to have a privacy officer in place so that if, as a user, you want to complain, you have a concern about how your privacy is being treated by a company, you can find some channel, some person to contact. But across the board, companies are not doing enough to offer even such a path to remedy, let alone explain the process, what they will do when they receive a complaint, give insight into how they've dealt with such complaints, etc. And this touches on what Luca was mentioning, that if companies are basically even closing down the venues that you can find redress on by sort of ruling out any class actions you can take in court, and we want to ensure that individuals will not only be able to continue to seek access in court if they need to, but also find a way to have a much easier and quicker sort of way to find remedy with the company itself.
I fully agree with Alon, and this also reminds me current trend. I see a very worrying discussion nowadays in internet governance when people talk about the negative aspect of internet, like online hate speech and youth radicalization and child protection. Many people will suggest a very hard counter strategy measures to take on this. And this would risk in compelling the companies to take the easy route of censoring and removing content on their own without a process, without appeal, without remedies. And so I think this should really be addressed by the terms of service as well, because this kind of counter strategy can never serve a full solution. It's maybe half solution. And we need more process and remedy and appeal to be in place to eventually to solve the problem.
Thank you. Given we still have some time, we lost 2 panelists, by the way, because we changed room. So we have even more time than we expected for questions. If there is nothing burning, yes, there is a question. Otherwise, I have one that is a bit a provocation, and maybe you can bear me with.
You can wait a little bit with your
Sure.
provocation
Go
and
ahead.
allow our audience.
Actually, so I don't. Oh, first of all, my name is Michael Ogia. I'm an ISOC I'm an Internet Society ambassador. I actually don't have a question. I just wanted to raise 2 resources that I recently came across that are related to terms of service. One of them is called, forgive me, it's called TOS ;DR, terms of service didn't read, a play on too long didn't read. Basically, there's this website now that reads terms of services and then reduces that down into digestible ways. I'm not sure if you're familiar with that. Another one that I also recently came across was, it's called iTunes Terms and Conditions, the graphic novel, and basically this Tumblr artist went through and made a 47-page graphic novel out of the iTunes terms and conditions. So no question, just wanted to bring that to your attention in case you're interested.
Yeah, it's a shame that the TOSDR site isn't better maintained. It's actually a little bit out of date in some respects, which is a shame because it's actually a really useful resource. And there's an associated one called tossback.org, which is also not maintained, and I feel bad about that because that's partly an EFF project. There was a TOS back is basically tracking changes to terms of service so that you can be notified whenever a terms of service document is changed, because even though under some consumer laws the company is required to notify you of changes of service, under other consumer laws, such as in the United States, they're not necessarily required to do so. They're entitled to have a condition in there that says you have to come back every to read the terms of service and find any changes for yourself, which of course is ridiculous. So tossback.org is a useful resource, and I think there is a beta version too, which you can find I think at tossback.eff.org, but if that doesn't work, you can come and see me later and I'll direct you to it.
Just a very short follow-up on what Jeremy was saying with regards to informing users of changes to terms of service. Indeed, as I mentioned, this is something that we were looking at, and these are, what you mentioned, these are some things that we would often encounter in doing research on terms of service, that the company says, we will inform you on this website, on the terms of service site, if we make any changes. Well, if almost no one reads terms of service in the first place when they have to consent to it, who's going to come back to the website of terms of service and sort of try to identify what changes have been made, etc.? When we are being asked, so if you look at the results of your research, of the index, and you sort of try to identify what can companies easily improve on, this is one of these things. There's no way, there's no reason, there's no strong argument for companies holding back on simply informing users of the changes, but also to provide an archive of previous terms of service. Some companies are doing a good job of this. They provide a red line archive. They provide you with line-by-line insight how terms of service have changed over time. Others simply put up the newest version, and if you're lucky, you can find an older version somehow that allows you to compare in a difficult way what changes have been made. But oftentimes they don't provide such information, and this is something that companies could very easily do.
Also, just a quick note on that, since I have the information on me, the data with me. This study from 2008 found that in US, users should reserve 8 hours a day for 76 days of 1 year to read only the privacy policies of around 1,500 pages that they visit every year. And considering that every page you visit might be collecting data of you and tracking you, that amount from 2008 to today, this might have been even bigger, even long time. So it's very difficult to believe that users will find or will track the changes of on the terms of service, and that's why this type of project is very relevant and important.
I'm just thinking what colleagues just said about the users. They don't read the TOS, and actually they couldn't even understand if you really open it. Can I draw a lesson from a traditional media world that there's accountability mechanism in place? UNESCO has a traditional mandate promoting press freedom, and we have observed that you cannot just work on the law, national measure, but we need to encourage the self-regulatory mechanism, the independent press council to be created to help the newspaper in the one country. You have created an independent body to oversee, to monitor, to supervise the ethical dimension of the journalist. The stronger this kind of independent self-regulation body functions, the easier they can, they will refrain them from the heavy regulatory frame from the governments. So I think maybe for the intermediaries, of course, not media, but maybe the global, regional, and national accountability mechanism should be considered to be in place, like the GNI. They can help the whole industry to share some common terms of services. They have experts, independent experts to help to follow up the changes, and that may be even better.
Do we have any other question or comment from the floor? From the online world? Okay, so please.
So I thought I never heard that they had class actions prohibition. Have you ever came across any action challenging that particular reference to class action? Because that's really abusive, right?
So the question is if you have any example of some organization or some user challenging the condition imposing the waiver of class action.
This is not exactly the same, but there was a case recently in France where a gentleman was contesting the deletion of a picture from his Facebook page because it was a nude and it was against Facebook's terms of use. And so he tried to bring his suit in the French court, and of course Facebook responded to say, oh no, you have to come to California to file your lawsuit. And the French court decided that it did have jurisdiction, so in that case the terms of service were overridden.
We have two class actions, actually, against Facebook and Yahoo, but because they didn't comply the decisions of judges in Brazil. They refused to comply these decisions because they have only a representation in Brazil, and they are located in United States. So, but we didn't have any legislation about internet until our Marco Civil, the internet. That's a law about internet, and the Marco Civil states that. Companies who is located in Brazil or do service in Brazil has to comply the law, the judges and the decisions from Brazil.
And I think now is the moment of the Nicolas provocation that we were all attending.
Thank you. No, it was just, in the absence of other questions, I wanted to continue along the line of the question posed by the remote participant. So what can we do? What kind of tools are companies developing to ensure better data protection? And So I wanted to tell you about this fact that recently there are many services which are promising more control to users over their personal data. In particular, these are called personal data stores, where people can entrust their personal data to some company, which offers those essentially to any company that is willing to buy them, and in exchange the users will receive a token. So this could be either a monetary value, or it could be a coupon for a service of the company, for example. However, there is a problem there, because we don't know exactly what's the value of our data. So we all say that personal data is the currency with which we pay many of the services that we access, but we don't know actually what are the conditions under which those data are going to be used and shared with third parties, how long they are retained, etc. So to that effect, I mean, I think it's almost like entering a contract in a real world, where you are giving someone the ability to get your money, or enter your house, and under very vague circumstances. So from a data protection perspective, there are, I think, 5 elements that are problematic, and I'm wondering about, what's the feeling in the room of what is the most problematic aspect in having vague terms of service under a data collection perspective. So how much data the company is collecting, data retention, so for how long the company is collecting the data, data aggregation, so how much it's combining those with other databases to which they have access, then security of the data, so protection vis-à-vis third parties. So what are the security standards that the company is using, and then further use of the data, so how the company can change the purpose for which it's processing the data. So, yeah, under that perspective, if you were given the power, to judge as a regulator on which of these 5 aspects you would like to crack on, essentially, to ensure that there is a fairer transaction, which one do you think is most important? Yeah.
Well, advising legislators, I think I'm happy to answer this. The collection, privacy by design is the easiest way to solve a lot of the other problems. If you don't collect data, you can't misplace it, you can't accidentally give it away. You can't aggregate it, and you can't sell it to third parties with or without consent. Data minimization is the best way of stopping misuse of data. And actually, it's a sound principle for companies as well, not bulking up on data just because they might need it in the future, but rather just ensure they get the data they really need for their business model. So it's not an impossible sell.
I just want to point out that this is what the other side of the story says. According to companies, with big data, you cannot, know how they're going to be useful in the future. So, just to mention, there is this other side, and the challenge is, of course, to try to limit how much they can repurpose those data that they collect for one specific purpose. Yeah.
Well, I can go outside the box and say transparency in all of these fields rather than any of those. So the actual information about all of these things, how the company handle it, what they collect, why they collect, how long they retain, that is the most important thing. If we don't know that, we don't know what to criticize. If we know exactly how they handle the data, then we can also discuss how we want them to handle the data. One thing, the security of the data, liability if there's a data breach for the data controller would be useful, and a requirement to report any data breach, which is currently quite weak in most countries, would be an excellent first step. If there is a liability, if they misplace your data or have a security breach, then the companies will be less inclined to collect data they don't think they need, because it's a risk. But none of this will be achieved by one method. We can't legislate about all of this. It will never be enough. Any legislation will be watered down by corporate interest in the process. There is no place in the world where laws are made solely for the interests of the individuals. So law can only take us that far. Then we need best practices between companies. We need self-regulatory measures that put an even higher standard than the law. And we need a public debate about a topic that constantly puts pressure on companies so they realize they actually gain goodwill and consumers by having a sound approach to data.
Are you also equally confident about self-regulatory measures?
Can I chip in and say I didn't say self-regulatory measure was enough. It's one part that is necessary. It's not enough. We need a high standard set by regulation and then self-regulatory measures on top of that. And a very basic thing is stop talking about personal data as property. It's a contractual arrangement where you allow companies to interact with some of your personal data. It's always yours. It's never theirs. Don't see it as property. See it as a contractual arrangement. That's a good frame of mind to discuss data, with personal data when it comes to companies.
Yeah, I definitely agree that companies should do a lot more to offer transparency on these things. There's no company that I've seen that gives you any sort of insight in the form of, I don't know, a profile or a dossier of what the company holds about you. To have just some clear understanding with very practical examples of what it is that a company holds about you. That should be offered to individuals, to consumers, so that they can make that choice. They can then make that choice. Okay, this is what the company holds about me. This is what they do with it. And on that basis, they can make their choice if they want to interact with the company or not. But to piggyback on Nicola's question, I'd be really curious to put this to the audience that we have here. I assume that many of you are interested in privacy and perhaps concerned about your privacy and likely want to make sure that your privacy is respected. What are the things that worry you about your data? What aspect of when a company interacts with your data, when they collect it or share it or keep it, what is it that troubles you or that you are worried about?
Reaction there.
Hi, my name is Fabrício Pessoa from Axur, Brazil. And I think that there is one very important point about all of this is that before we start this, well, actually, while we discuss about all these things that we've been discussing here, there's one very important point is that are the end users ready to understand those terms, right? If people don't understand how internet works, how can they decide? And I think this is one of the main things that I see, because I don't come from a technical background, and not coming from a technical background and going to lots of discussion about cybersecurity and privacy. And so what I see is a lot of tendency of trying to decide what people should have or should not have, while people should be telling that, right? And so, but how can they tell, how can they speak up if they don't understand the basics, right? For example, when we talk about cars and we think about 30 years ago that people didn't wear seatbelts because they didn't think it was important, they didn't see the risk on that, right? And with campaigns and awareness campaigns, people started realizing, hey, wait a second, we should be doing this and we should be doing that. But they understood the point. And I think that this is the point that we are lacking, you know, that when the internet started developing very fast towards usability, but not towards security. So now we have everybody using internet and not understanding how it works, and so that they cannot decide what is safe, what they want or not. For example, I am one of the guys that uses Facebook, and I know what they do with my data, but I have contacts all over the world, and this is the only way I can keep in touch with them. But I chose that. That was my choice, right? And I decide what I put, and I know that what I put there is going to be used by them. But most people don't. And I think that if all of a sudden now we start changing the rules of the game, kind of how many people would say, no, wait a second, I'm not going to use that anymore. It's just convenient, right? But that's the point. People need to understand, they needed to understand how the information goes through all the path on the internet, how the data is being used. And I think this is the main principle of all the discussion.
We have a comment from Parminder.
Thank you. Parminder from IGF for Change. And as a segue to my point, I would use what the previous speaker talked about, wearing seat belts. And I still wear seat belts largely because law mandates it, rather than because of an awareness thing. I mean, just people work like that. You know, the world works like that. The most people I know, they see a highway and they suspect police may be there, and then they put the seat back. So the question I'm trying to come to is that the terms of service are issues of private contract, and we are moving, in a world where the governance is more based on private contracts, and the relationship between the social contract-based governance and private contract-based governance is shifting. A lot of areas which were earlier based on social contracts are now being taken over by private contracts. And we have to reclaim that public space. And I see a lot of people speaking about law, etc., which supports better data rights. But we also should realize that at least Brazil is a large country and has some leeway to even talk about it. And 80% of the countries simply have the economic structures, the new economic structures based on the internet are so strong that it's either take it or leave it. And they simply have no choice at all. Brazil also has limited choice, and India also have a limited choice. So what I'm trying to come to is that it is a global phenomenon, and we need to start talking about norms of what is ownership of data, what is economic value of data versus data as a human right, what are those balances, and these kind of normative discussions and normative principles framing is to take place at a global level. It's not taking place, and right now there is a World Summit review taking place in New York. I was in New York last month, and you sit in that room, it looks like the world is going on very, very well. And there are no issues to be talked about. And we try to at least put words like data governance and platform governance into the text. And people say, what is this? Let's not talk about it. So, I mean, if you don't produce a space globally like WHO talks about health norms and UNESCO talks about education norms, you shrink away from putting those spaces where these norms are built. We wouldn't make a lot of progress, and it's more true of smaller countries, 80% of countries which are not economically powerful. They just, they're given an option, either take it or leave it, and that's how the system works.
I think Xiang Hong had a reaction on this.
Yes, very quick comments. Yes, as I just mentioned, that we do need a strong self-regulatory framework, and we do need a global, regional, national accountability mechanism in place to help users to defend their rights. But on the other hand, yes, I agree that particularly in developing world, that citizens they are not aware of their rights. Yes, they don't understand technology. They don't understand what implication this service can bring to their daily life. That's why you see that so many people, children, they just give up their privacy easily without thinking about it. So we are promoting media information literacy, digital literacy to help everybody to understand how internet media works, how it can impact their civil liberties. This will be a very crucial issue.
I think also Jamila had a reaction on this.
Yeah, it's just a quick reaction and some type of provocation before doing it. I would like to say I don't disagree with anything that was said here, just for us to try to think about these things. I mean, is this really new? Is the fact that people do not understand the type of contract they are going into, is it really new? Is it something from the online world? Or is this just there is just a multiplication of these situations, because people do not understand technology and do not understand how other services are offered to them. And regulation, consumer regulation, somehow try to address to that. So it's not like the terms of service or just giving people more information on how these things work will solve the problem, and people's ability to get knowledge of all this is also limited. So if for us doing this analysis of 50 platforms, it was super difficult to understand all the technical challenges and the technical issues that are behind the collection and tracking and putting an ad, because none of these things are explicit on the terms of service. They are not saying, we put this ad and we will track you. They are giving that information in other words. So I think there is a mixture of things. And the other problem that I would like to point out is that if we change the model from this by default model to an opt-in model, what in the end are the options users will have not to opt in? If we have such limited offer of some types of services, and the trend is for this to be concentrated. So it's a take it or leave it model, and if we change from default to opt-in, it will continue to be a take it or leave it model. So I think all these discussions are really connected to several other discussions that we are having. I mean, there are some initiatives talking about decentralization of the internet and some other things, some things that were discussed in the previous session on the dynamic coalition on platform responsibility. I think these all should be taken like in a more general perspective. And just to conclude, I really agree with Matthias' comments on how all these layers can complement, and there is also this technical layer that should also be taken into account.
Thank you very much, Jamila. Actually, thank you for the plug to the Dynamic Coalition on platform responsibility. I think we have seen also from Parminder's comment that there is a need for this kind of forum to discuss how to approach from a governance perspective, especially the use of data. I mean, right now, to date, we don't have such forum, and the Dynamic Coalition perhaps is one initiative that goes in that direction. It would be nice, if you are interested in these issues, if you could join the mailing list. That's already the first step. We heard in the first session that we had this afternoon that also the UN Special Rapporteur for Privacy and the Council of Europe are interested in having some ongoing discussion. Possibly we might co-organize some event over the course of the year. And that's probably when we will have also more results from the Terms of Service and Human Rights Project. So we'll be happy to share that in the list. But from a more positive note, I think there are many possibilities in the laws already that we can look at. So both the European regulatory framework and the Brazilian regulatory framework offer the possibility to create codes of conduct. And regulators have actually a role to promote the code of conduct that they recognize as valuable in this respect. And so maybe in the future some technical solution indeed that can recognize automatically the companies who are complying with this code of conduct and giving the ability for users to see immediately, maybe through a browser plugin, when those companies are the good ones. That's a good way to go. Then there is much work to be done on how to make terms of service readable and easily understandable. But I think we can also, to that extent, have someone with the expertise to do this and adopt a technical solution that make it visually apparent to consumers every time they access websites. So, yeah, thank you for all the inputs. I think it has been a valuable discussion, and hopefully we can continue over the course of the next year, leading to the next IGF. Thank you very much.